Unit 9, Basic Contract Law. Learning Objectives. When you have completed this unit, you will be able to accomplish the following. Define the essential elements of a valid contract and provide examples of various contract descriptors, such as expressed or implied, bilateral or unilateral, executory or executed, valid or void. Describe the impact of the following concepts on the formation of a contract. Reality of consent, the revocation of an offer, the parole evidence rule, the statute of frauds, time is of the essence, assignment, the statute of limitations, novation and discharge, and the legal remedies of a breach of contract. Discuss the broker's authority to prepare contracts. Contrast examples of different types of auctions. Key terms: addendum, amendment, assignment, auction, bilateral contract, breach of contract, compensatory damages, consequential damages, consideration, contract, counteroffer, earnest money deposit, executed contract, executory contract, express contract, implied contract, legality of object, legally competent parties, liquidated damages, meeting of the minds, mutual assent, novation, offer, offeree, offerer, offer and acceptance, parole evidence rule, reality of consent, rescission, specific performance, statute of frauds, statute of limitations, time is of the essence, unenforceable contract, unilateral contract, valid contract, voidable contract, void contract. Learning objective. Define the essential elements of a valid contract and provide examples of various contract descriptors, such as expressed or implied, bilateral or unilateral, executory or executed, valid or void. Contracts. In the course of their business, brokers use many types of contracts and agreements to carry out their responsibilities to sellers, buyers, landlords, tenants, and the general public. Among these are listing contracts, buyer agency contracts, sales contracts, option contracts, land installment contracts, and leases. The general body of law that governs the operation of such contracts is known as contract law. Here we will discuss basic contract law that applies to all types of contracts. A contract is a legally enforceable promise or set of promises between legally competent parties, supported by legal consideration, to do a legal act that must be performed and for which the law provides a remedy if a breach of promise occurs. A contract must be the following: voluntary, no one may be forced into a contract. An agreement or a promise. A contract is essentially a legally enforceable promise made by legally competent parties. The parties must be viewed by the law as capable of making a legally binding promise. Supported by legal consideration. A contract must be supported by some valuable thing that induces a party to enter into a contract, and that must be legally sufficient to support a contract. About a legal act. No one may make an enforceable contract to do something illegal. Depending on the situation and the nature or language of the agreement, a contract may be express or implied, unilateral or bilateral, executory or executed, valid, unenforceable, voidable, or void. Express and implied contracts. Depending on how a contract is created, it may be express or implied. In an express contract, the parties state the terms and show their intentions in words to that effect. An express contract may be either oral or written. The statute of frauds requires all contracts for the transfer of an interest in real estate to be in writing. Therefore, all real estate contracts should be expressed written contracts. In an implied contract, the agreement of the parties is demonstrated by their actions or conduct. In a seller-agency relationship, a listing agreement is a written, express contract between the seller and the broker firm, naming the broker firm as the fiduciary representative of the seller. Example: Hugh approaches his neighbor, Bob, and says, "I will paint your house today for $500. Bob replies, "If you paint my house today, I will pay you $500. Hugh and Bob have entered into an express oral contract. Betty writes, signs, and delivers an offer, which Sam then signs. Betty and Sam have an express written contract as soon as Betty learns that Sam has signed Betty's offer. Ken goes into a restaurant and orders a meal. Ken has entered into an implied contract with the restaurant to pay for the meal, even though payment was not mentioned before the meal was ordered. Bilateral and unilateral contracts. Contracts may also be classified as either bilateral or unilateral. In a bilateral contract, both parties promise to do or refrain from doing something. One promise is exchanged for another. A real estate sales contract is a bilateral contract because the seller promises to sell a parcel of real estate and deliver title to the property to the buyer, who promises to pay a certain sum of money for the property. Most real estate-related contracts are bilateral in nature. In a unilateral contract, one party makes a promise to induce a second party to do something. The second party is not legally obligated to act. However, if the second party does comply, the first party is obligated to keep the promise. For example, a seller who agrees to give the buyer 4 months to decide whether to buy a property is giving the buyer an option, which is considered a unilateral contract. Executed and executory contracts. A contract may be classified as either executory or executed, depending on whether the agreement has been performed completely. An executory contract exists when something remains to be done by one or both parties. A sales contract, signed by all parties, pending closing, is an example of an executory contract. An executed contract is one in which all parties have fulfilled their promises, and therefore fully performed the contract, such as a sales contract that is closed. Validity of contracts. A contract can be described as valid, void, voidable, or unenforceable, depending on the circumstances. Legal effects of contracts. A valid contract complies with all the essential elements of a contract and is binding and enforceable on both parties. A void contract is one that has no legal force or effect. It is unenforceable in a court of law because it does not meet the essential elements of a contract. However, a void contract may be fully executed unless one of the parties disaffirms it. Example: a seller enters into a purchase agreement with a buyer who has been adjudicated incompetent by a court. The contract is void because both parties must be competent to create a valid contract. A voidable contract is one that seems, on the surface, to be valid but may be rescinded or disaffirmed by one of the parties based on some legal principle. If someone makes a contract while drugged or intoxicated, the contract is voidable by that person. A voidable contract will be considered by the courts to be valid if the party who has the option to disaffirm the agreement does not do so within a prescribed period of time. A contract with a minor is voidable by the minor. A contract entered into with a person who is known to be mentally ill is usually voidable during the mental illness. On the other hand, a contract entered into with a person who has been adjudicated as incompetent is void. An unenforceable contract has all the elements of a valid contract. However, neither party can sue the other to force performance. Unenforceable contracts are said to be valid as between the parties because once the agreement is fully executed and both parties are satisfied, neither has reason to initiate a lawsuit to force performance. For example, an oral agreement for the sale of a parcel of real estate would be unenforceable because the statute of frauds requires that real estate sales contracts be in writing to be enforceable. However, if both the seller and the buyer perform their obligations under the oral agreement, a valid transfer can occur. But if one of the parties refuses to perform, there is nothing the other party can do to compel performance. Essential elements of a valid contract. In general, the 4 essentials of a valid contract are as follows. 1. Legally competent parties. Both parties to the contract must be of legal age and have sufficient mental capacity. In North Carolina, 18 is the age of contractual capacity. Persons younger than 18 years of age are deemed infants or minors. Generally, minors' contracts are voidable by the minor or may be canceled before or within a reasonable time after the minor reaches age 18. A broker should inquire carefully into the ages of both the purchaser and the seller of real estate. Advanced age, in contrast, may be an indication of a person's incapacity to contract as a result of senility. In questions of legal competency, it may be desirable to consult with the client's lawyer. A party who understands the nature and effect of the contract has sufficient mental capacity. If a person is not mentally competent in fact and enters into a contract, that contract would be voidable. Mental capacity is not the same as medical sanity. Similarly, an illiterate person has mental capacity and can still be a party to a contract. 2. Mutual assent or deliberate agreement. An offer by one party is accepted by the other party. Offer and acceptance means that there must be a meeting of the minds. Courts look to the objective intent of the parties to determine whether they intended to enter into a binding agreement. The terms of the agreement must be fairly definite and understood by both parties. Furthermore, the acceptance must be actually communicated to the offerer. 3. Legality of object. To be valid, a contract must not contemplate a purpose that is illegal or against public policy. If a contract calls for immoral performance, discrimination, or a criminal act to take place, the contract is void. Consideration. Courts will not enforce gratuitous promises. Consideration is something of legal value, bargained for and given in exchange for a promise, or an act. Any return promise to perform that has been bargained for and exchanged is legally sufficient to satisfy the consideration element. For example, the purchase price is the consideration in exchange for the transfer of the property in a real estate contract. In addition to money, other valuables such as antiques, jewelry, and stock could be used as consideration, though they would be highly unusual in a real estate contract. A binder or an earnest money deposit is merely an expression of good faith and is not required to create a valid contract. Learning objective. Describe the impact of the following concepts on the formation of a contract: reality of consent, the revocation of an offer, the parole evidence rule, the statute of frauds, time is of the essence, assignment, the statute of limitations, novation and discharge, and the legal remedies of a breach of contract. Formation of the contract. Requirement for reality of consent. Contracts signed by a person under duress or undue influence are voidable by that person or by a court. Extreme care should be taken when one or more of the parties to a contract are elderly, sick, in great distress, or under the influence of alcohol or drugs, both legal and illegal. To be valid, every contract must be signed as the free and voluntary act of each party. Misrepresentation, fraud, or mistake of fact could render a contract voidable by the injured party. In the absence of these factors, the reality of consent has been reached. Mistake of fact. A contract may be voidable if the mistake of fact involves a material term, is mutual, and is not the result of fraud or negligence. However, a unilateral mistake of fact does not release parties from their obligations. Example: Tammy negotiates with Keith to purchase a tract of vacant land Keith owns. Keith honestly believes and tells Tammy that the tract contains 145 acres. Tammy relies on Keith's representations and the parties sign a contract. Prior to settlement, it is discovered that the tract contains only 120 acres. The contract most likely will be held voidable at Tammy's election due to the magnitude of the mistake relating to a material term that both parties mistakenly believed. Mistake of law. Unlike mutual mistakes of material fact, mistake of law does not excuse a party's obligations under a contract. The reason is because everyone is presumed to know the law. Example: the case of Willis v. Willis, in which a widow created a will but later signed a warranty deed conveying real property she owned to one of her children, reserving a life estate for herself. The grantee child died before their mother, and at this point the mother wanted to deed the property to one of her other children. Had she devised the property to her child, she could have changed the terms of her will. Once she conveyed the property to her son by deed, she could not later change her mind and rescind the deed. The North Carolina Supreme Court held that a unilateral mistake by the grantor as to the law will not support reformation of a deed. Fraud. If a party or a party's agent engages in fraud, then any resulting contract may be voidable at the option of the party being deceived. The elements of fraud include either a false representation or non-disclosure of a material face, made with knowledge of its falsity or in reckless disregard of its truth, with the intent that it be acted upon by the other party, and that is acted upon by that party to their injury. Fraud done not automatically make a contract absolutely void. The defrauded party has the option to avoid the contract or to enforce it. Example: Jeff, a listing broker, tells an interested buyer that the developer is working with the county to pave the gravel road leading into the subdivision. The developer has stated to Jeff that they will never pave the road and now refuse to pave the road. Jeff did not make this statement regarding the road to any other potential buyers who did not ask about the road. If Jeff's misrepresentation induced this buyer to purchase the lot, the buyer may bring an action for damages because the lot is worth less with a gravel road than a paved road. Also, the buyer may be able to rescind the contract. Duress. Duress is overcoming the will of a person and forcing the person into a contract by violence, or a threat of violence, imprisonment of a threat of imprisonment, threat of physical injury to a family member or others, threat of wrongful destruction, injury, seizure, or withholding of one's property, or any other wrongful act that compels a persona against their will to enter into a contract. The contract may be voidable by the injured party. Example: undue influence. Undue influence occurs when one person takes unfair advantage of another in a contractual relationship because of the party's particular and peculiar relationship, or one party's weakness of mind, or due to a party's particular necessities or distress. A contract may be voidable if it was induced by reason of the fiduciary's undue influence over the other party. Note: example, persons acting in a fiduciary capacity, such as attorney-client or physician-patient, may have an unfair advantage because the other party relies upon and gives undue weight to the fiduciary's counsel. Revocation of an offer. An offer may be revoked or withdrawn by the offerer at any time prior to acceptance if the revocation is communicated directly to the offeree by the offerer. It also can be revoked if the parties are notified through their agents. Any attempt by the offeree to change any of the terms proposed by the offerer creates a counteroffer. The offerer is relieved of the original offer because the offeree has, in effect, rejected it by making changes. The offerer can accept the offeree's counteroffer, reject it, or, if the offerer wishes, make another counteroffer. Any change in the most recent offer results in another counteroffer until one party agrees to the other party's counteroffer and both parties sign the final contract. Counteroffers may be made by pen and ink changes as long as each individual change within the offer is initiated and dated by all parties in addition to the signatures and dates necessary at the bottom of the contract. To avoid confusion and mistakes, signing a new NCBA, NCOR 2T offer to purchase in contract that incorporates all the changes is the preferred practice. An offer or a counteroffer may be revoked at any time before it has been accepted. The offeree or the offeree's agent must receive notification of the revocation. The contract should stipulate the manner of acceptance. Generally, an offer is not considered accepted until the person making the offer has been notified of the other party's acceptance. There is an important difference between an offer and a contract. Offers may be terminated by the following: if the offeree rejects the offer or creates a counteroffer. If the offeree fails to accept within the prescribed time stipulated in the offer. Within a reasonable time, if a time of acceptance is not prescribed. Prior to acceptance, if the offerer communicates a revocation of the offer. By the death of the offerer or offeree. If an offer is terminated, all monies, if any, are returned to the offerer and there is no penalty to the offerer. Reminder: an offer does not become a contract until the person making the offer has been notified of the other party's acceptance. When the parties communicate through an agent or at a distance, questions may arise regarding whether an acceptance, a rejection, or a counteroffer has effectively taken place. The real estate broker should transmit all offers, acceptances, or other responses as soon as possible to avoid such problems. In North Carolina, these notifications should be delivered as soon as possible, but in no event later than 3 calendar days after execution. Remember that as an agent, a real estate broker stands in the shoes of the principal. Communication of acceptance or revocation to an agent is the same as communication directly to the principal. Example: a buyer who is represented by an agent has presented an offer to the seller on Monday. On Tuesday, the seller decides to accept the offer. The seller signs the offer to purchase, and on Tuesday night, the seller's agent tells the buyer's agent that the seller has accepted the buyer's offer. Because it is so late, the buyer's agent decides to wait until Wednesday to tell the buyer that the seller has accepted the offer. Early Wednesday morning, the buyer changes his mind and decides to revoke the offer. It is too late. The communication of the seller's acceptance to the buyer's agent is deemed to be communication to the buyer. Because the offer has been accepted and communicated, the buyer can no longer revoke his offer. They are under contract, agreement in writing and signed. Not all contracts must be in writing to be enforceable. However, every state has adopted the common law doctrine known as the Statute of Frauds, which requires that certain types of contracts be in writing to be enforceable in a court of law. Most notably, all contracts for the transfer of an interest in real estate must be in writing, with the only exception being leases of 3 years or fewer from the time of their making. The North Carolina Statute of Frauds requires that to be enforceable in a court of law, conveyances of interests in real property, such as deeds, contracts for sale, mortgages, options, easements, and certain leases and contract modifications, must be in writing and signed by the party to be bound or by the party's legally authorized agent. A listing agreement or a buyer representation agreement is an employment contract and is not covered by the North Carolina Statute of Frauds. However, North Carolina Real Estate Commission rules require that agency agreements be in writing. The purpose of the North Carolina Statute of Frauds is to prevent fraudulent proof of an oral contract. The Parole Evidence Rule, another heritage of the common law, is a rule of evidence that dictates that no oral agreements that contradict the terms of a written contract may be considered in a lawsuit based on the written agreement. The written contract is assumed to be the complete manifestation of the agreement of the parties. The many exceptions to the rule include evidence that a contract was entered into illegally, or evidence intended to clarify ambiguous contract terms. The party who drafted the ambiguous terms would most likely be ruled against in a court hearing. In practice, if there is any ambiguity in a contract, the courts generally will interpret the agreement against the party who prepared it. For example, if the seller prepares the NCBA, NCOR2T offer to purchase in contract, and one of the terms is ambiguous, the court will interpret that term in favor of the buyer. Performance of contract. Under any contract, each party has certain rights and duties to fulfill. The question of when a contract duty must be performed is an important factor. Many contracts call for a specific time at or by which the agreed-on acts must be completely performed. In addition, many contracts state that time is of the essence. This means that the contract must be performed within the time limit specified, and any party who is not performed on time is liable for breach of contract. If an offeror includes time is of the essence in the offeror can still revoke the offer at any time prior to acceptance. When a date is noted in a contract but is not followed by the phrase, time is of the essence, the date is a general target date that all parties should attempt to meet. If the promised action is not completed by the target date, the contract is not automatically terminated or made voidable. As long as the action is completed within a reasonable time, the contract will probably still be binding on all parties. The definition of a reasonable time would necessitate a court ruling. When a contract does not specify a date for performance, the acts it requires should be performed within a reasonable time. The interpretation of what constitutes a reasonable time will depend on the situation. Generally, if the act can be done immediately, such as a payment of money, it should be performed immediately unless the parties agree otherwise. In practice, despite the best efforts of buyer and seller, it may be impossible to close a transaction on the date stipulated. The seller may not be able to complete necessary repairs before that date. The buyer's lender may be swamped with loan applications and unable to provide funding on the date requested. Buyer and seller can adjust the closing date by a modification of the contract, a written amendment signed by all parties. The broker may negotiate the new term but may not sign the modification on behalf of any of the parties. Contingencies must be anticipated to allow sufficient time for completion when contracts are executed. A contingency is a provision in a contract that requires a certain act to be done or a certain event to occur before the contract becomes binding. It is a condition of the contract. Assignment and novation. Occasionally, after a contract has been entered into, one party wants to withdraw without actually terminating the agreement. This may be accomplished through either assignment or novation. Assignment refers to a transfer of rights or duties, but not the liabilities under a contract, to a third party. Rights in a contract may be assigned to a third party unless the agreement forbids such an assignment. Duties may also be assigned, but the original obligor remains secondarily liable for them. The exception to this rule is a contract for personal services, which may not be assigned. Most contracts include a clause that either permits or forbids assignment. The NCBA, NCOR2T offer to purchase in contract is not assignable without mutual written consent. An assignment does not terminate the contract or change the terms of the contract. Example: Joe signs a 5-year lease on a storefront. In 2 years, a rival decides to buy Joe's business. Joe accepts and turns over all of his inventory and the remaining period of his lease. Joe's landlord agrees to allow Joe to assign the lease obligations to the business new owner. The new owner, the assignee, has primary responsibility, but Joe, the assignor, is also liable to meet all lease terms. Novation is another way to avoid the terms of an existing contract without breaching that contract. Nova means new, and novation is the substitution of a new contract for an existing agreement with the intent of extinguishing the old contract. The new agreement may be between the same parties, or a new party may be substituted for either. The party's intent must be to discharge the old obligation, therefore, it does terminate the original contract. The new agreement must be supported by consideration and must conform to all the essential elements of a valid contract. In the previous example, if Joe's landlord agreed to rescind Joe's lease and sign a new lease with Ben, this would be a novation. Joe would have no further liability for the lease. Discharge of contract. A contract may be performed completely, with all terms carried out, or one party may materially breach the contract. A contract also may be discharged by various other methods. These include the following: partial performance of the terms of the contract. This is sometimes referred to as accord and satisfaction. When one party accepts something less than agreed on as complete performance, the contract is considered discharged. Substantial performance. One party has substantially performed the contract, but does not complete all the details exactly as the contract requires. Such performance, for example, under construction contracts, may be sufficient to force payment, with certain adjustments for any damages suffered by the other party. Impossibility of performance. An act required by the contract cannot be accomplished. This does not refer to a party's inability to do something, rather the impossibility of performing it. Mutual agreement of the parties to cancel. Release. When both parties agree that one or both are released from their obligations under the contract. Subsequent modifying agreement. A new contract changes the terms of the original contract. Operation of law. This is in terms of voiding of a contract by a minor as a result of fraud or the expiration of the statute of limitations, or as a result of the alteration of a contract without the written consent of all parties involved. Bankruptcy can also discharge a contractual obligation. General rules for interpretation of contracts. Rules have been developed by the courts to help them in determining relatively uniform standards for interpreting the words used in contracts. Remember, brokers are not allowed to draft legal documents for others. This is considered the unlawful practice of law under NCGS 936. Also remember, the parole evidence rule dictates that no oral agreements that contradict the terms of a written contract may be considered in a lawsuit based on the written agreement. The most important rules are as follows. Preliminary negotiations inconsistent with the terms of a final written contract are not admissible as evidence to alter a contract's terms. A contract is interpreted as a whole, and all writings forming a part of the same transaction are interpreted together. If possible, a contract will be construed as to render it reasonable rather than unreasonable. Ordinary words will be interpreted in their popular sense unless circumstances indicate that the parties intended to use them in a special sense. Where there is a conflict between pre-printed versus written provisions of a contract, the preferred interpretation favors written provision over pre-printed language. Ambiguities in a contract typically will be construed against the party who prepared the provision or who chose the words that create doubt. Default, breach of contract. A material breach of contract renders the agreement broken beyond repair. For example, material breach of a real estate contract might be a party failing to close the transaction. A breach of contract is a violation, without legal excuse, of any of the terms or conditions of a contract, as when a seller breaches a sales contract by not delivering title to the buyer under the conditions stated in the agreement. The non-defaulting party has certain rights. If a party to a contract defaults, the non-defaulting party has the following alternatives. The injured party may sue the breaching party for money damages or compensatory damages. Money damages are awarded to the injured party to compensate him or her for the breach of the contract, not to punish the party who breached the contract. The amount of the money damages should be only what is necessary to make the party whole, that is, put the party in the position he or she would have been in if the contract had been performed as agreed. Thus, in many jurisdictions, the buyer can be sued for compensatory damages if the earnest money is not adequate to cover the seller's losses. The injured party may be entitled to collect liquidated damages. Liquidated damages are defined as the amount of money that will compensate the injured party for breach, which the parties agree to at the time they enter into the contract. For example, in North Carolina, the earnest money deposit is considered liquidated damages in the event the buyer breaches the contract. The seller is entitled to keep the amount of the deposit as compensation for any injuries caused by the buyer's breach of contract. Consequential damages are special damages that might be obtained if the damages upon breach were reasonably foreseeable to the breaching party at the time of making the contract. It also allows the injured party to sue for lost profits. The injured party may file a court action, known as a suit for specific performance, to force the other party to perform the contract as agreed. Specific performance is ordered only when the subject matter of the contract is not readily available from another source, and when each party has the ability to perform the contractual obligations. Because every parcel of real estate is considered unique, a suit for specific performance brought by the buyer against the seller under a purchase and sales contract may be successful if the buyer can demonstrate that the property is unique or rare. Sellers are seldom successful with this remedy against the buyer. Acceptance of liquidated damages is a more likely remedy against a buyer that has breached. The injured party may rescind the contract, which means the contract is declared invalid and both parties return to the position they were in before they entered into the contract. Rescission may be appropriate when facts were misrepresented or one party entered the contract under duress. A right of rescission may be written into the contract or may be stipulated by law, such as the 5-day right of rescission for a timeshare purchase or the 7-day right of rescission for a new condominium purchase. Statute of limitations. All states have laws that allow a specific time limit during which parties to a contract may bring legal suit to enforce their rights. The statute of limitations varies for different legal actions, and any rights not enforced within the applicable time period are lost. Misrepresentation or fraud could render a contract voidable by the injured party. True, the parole evidence rule dictates that no oral agreements that contradict the terms of a written agreement may be considered. True, learning objective. Discuss the broker's authority to prepare contracts. Broker's authority to prepare documents. A licensed real estate broker is not authorized to practice law and may be disciplined under GS 93A6 for attempting to perform any legal service. Because drafting legal documents for others is considered to be a legal service, Rule A-111 of the North Carolina Real Estate Commission states that an agent in a real estate transaction shall not draft offers, sales contracts, options, leases, promissory notes, deeds of trust, or other legal instruments by which rights of others are secured. Even if a client directs a broker to draft contract language, a broker is prohibited from doing so. A broker is, however, permitted to fill in the blanks on certain approved pre-printed documents when authorized to do so by the parties, provided the broker does not charge a separate fee for completing such forms. North Carolina Real Estate Commission Rule A-112 requires that brokers include all required data when completing pre-printed contracts, but prohibits the inclusion of brokerage compensation or a liability disclaimer in a sales contract. If there is no available standard or pre-printed form drafted by a North Carolina attorney for a certain type of transaction or condition, then the broker should refer the parties to their attorneys to draft appropriate language or documents. In practice, brokers are permitted to use electronic, computer, or word processing equipment to store pre-printed approved forms. However, the form may not be altered in any way before the form is presented to the parties to the contract. Brokers may, however, make written notes, memoranda, or correspondence recording negotiations of the parties to the transaction as long as they do not constitute binding agreements. The parties to the instruments may delete or change provisions, but the change or deletion must be marked to indicate. Contract forms. States vary as to what real estate contract forms brokers are authorized to use. Pre-printed forms are used for many kinds of contracts because most transactions are consistently similar in nature. The use of preprinted forms raises 3 issues: how to fill in the blanks, which text is not applicable to a particular sale and is to be ruled out by drawing a line through the unwanted words or by adding an amendment, and what additional clauses or agreements are to be included. All changes and additions should be dated and must include initials in the margin or on the rider by both parties when the contract is executed. Auction sales. The familiar procedure of a buyer making an offer to purchase, which the real estate agent then presents to the seller for acceptance or rejection, is avoided with an auction. Instead of merely presenting the offer to the seller, an auctioneer actually accepts the offer on behalf of the seller. After the auctioneer accepts the offer or bid, the buyer and seller formalize their oral agreement with a written document. A real estate auctioneer must have 2 licenses, a real estate license and an auctioneer's license. A mere crier of sales is exempt from real estate licensure. There are 2 types of auctions. Auctions with reserve. The seller reserves the right to stop the bidding if it becomes apparent that the high bid will be unacceptable to the seller. The seller must reject all bids before the auction is concluded and the auctioneer accepts a bid. Auctions without reserve. The seller agrees to accept the high bid, no matter what the terms of that bid. This is also called an absolute auction in North Carolina. Note that when the seller accepts any bid at any auction, no matter what type, the property is sold. A seller should fully understand that once the auctioneer declares a bid accepted, the property is sold on those terms because the auctioneer can bind the seller. Key point review. The following are characteristics of a valid contract. It is a voluntary agreement based on consent. If a mistake, misrepresentation, fraud, undue influence, or duress occurs, it is voidable by the injured party. The agreement or promise is based on an offer by one party that is accepted by the other. Mutual assent or meeting of the minds exists. Acceptance must be communicated by the last offeree to the last offerer. Revocation must be communicated by the offerer to the offeree prior to notification of the offeree's acceptance of the offer. A counteroffer terminates the original offer and initiates a new offer. It is made by legally competent parties, between parties of legal age who are able to understand the nature or consequences of their actions. A contract with a minor is voidable. It is supported by legal consideration, which is something of legal value, which could be love and affection, and free of undue influence or fraud. It is concerned with a legal act. A contract may be express or implied by conduct of parties, in some instances required to be in writing to be enforceable in a court of law, bilateral or unilateral, executed or executory, void if one of the essential elements is missing, or voidable if it may be rescinded or disaffirmed by one of the parties because one of the essential contract elements is missing, such as legal age or capacity of a party. Offers may be terminated by the following: revocation, a withdrawal by any acceptable method. Counteroffer, any change to the original offer is a rejection that creates a new offer. The Parole Evidence Rule dictates that verbal agreements cannot override the written contract terms. Contracts may be discharged by the following: performance, which completes the contract terms. Partial performance, if agreeable to both parties. Substantial performance, depending on circumstances. Impossibility of performance. Assignment. Novation. Breach by one of the parties without legal cause. Failure to enforce contract within statute of limitations. Mutual agreement of parties. Operation of law, as when a contract is void from inception. Rescission by one or both parties. Remedies for breach of contract include the following: compensatory damages is the amount necessary to make the injured party whole. Liquidated damages is the amount the seller will receive if the buyer defaults, such as earnest money or tenant security deposit. Consequential damages are obtained if the breach was foreseeable. Specific performance is a lawsuit that requires the party to perform contract obligations. Rescission is due to non-performance of some specific action.